Hello, hello, hello. This is attorney Mike Gravelin coming to you from Chicago as usual. Sorry, I had a little scheduling difficulty there. Forgot about my afternoon hearing. Had to roll over there. But we got some fun stuff today. I got a couple of fun clips. One was sent to me by Steve. I'll just say Steve. And it's a new judge. And then I've also got Lynise Bryant, a little bit from her, which is sort of interesting. And that officially qualifies her for her own playlist. I'm sure she's going to be very excited about that concept. So I'll put a card up at the end for the new playlist. She's had two other ones, but they were both fantastic. This is that is not treatment, and her response to the sovereign citizen, which Van Balen did a video on that and gave me a great shout out. I'd like to give a shout out back to him and say thank you. And of course, he's got a great channel. Most of you are probably subscribed over there anyway, but if you're not, go over and do it. He's got great material on there. But before we get to any of that, I just got a lot of comments and a lot of requests for my reaction to the Jussie Smollett situation. And I don't have a lot to add to it, but since it just happened yesterday, came back guilty in I think 6 or 7 counts. I don't have any grand take on it because I thought he was guilty. I never believed the story, not for 1 second. The events occurred very close to where I am in Chicago. I'm very familiar with it. I immediately thought there is no way that happened. There is no way that happened. When it got brushed under the rug, I was very disappointed, and I did not think it looked good. But I'm glad that the charges eventually were brought and justice was served. That he was found guilty. Thank you, Secret Squirrel. Actually, I found out I was on. I don't even know how to say it, Rakita Law or something like that. And I was checking out that because a lot of viewers have recommended that to me. By the way, that's a good channel too. I think he's a sharp guy with an interesting perspective. But I was over there checking out his channel, see what was going on, and I saw that's where I got the news that he was found guilty. Which I think is fantastic. Rakita had an interesting take on it. His whole thing was we don't have video, which it was frustrating. I would have loved to seen video of Jussie Smollett testifying. That would have been fascinating. Rakita takes the position that I don't agree with, although I like him a lot. I just don't agree with his position that all court hearings should be televised, or there should be a feed to all of them. I almost agree with it. I think that should be the presumption, but there are other things that there are reasons why it could be private. So the presumption would be that the feed goes out. But if somebody makes a showing for why this should not be on a feed, that would make sense. Also, I used to handle a juvenile call, and I handled testimony that was very sensitive from children. And trust me, that's not a good idea that would be made public. But so in short, I basically agree mostly with him, but with some minor differences. As far as Jussie goes, I mean, you probably have all seen this, but I've got no hotter take than this meme, which has been everywhere. I'm sure you've all seen it, but that made me laugh for a solid 10 seconds by myself when it came across my phone. I really enjoyed it. All right, so let's move on to the clips and get this party started.
Sir, please remove your hat. You are in court.
36th District Court.
Did you ever go to the breakout room, sir? Sir, did you ever go to a breakout room and speak to a lawyer? You're going to have to steady that device. Unmute yourself.
Yes, I did. I just spoke with an attorney.
And you came out with a hat on? All right, I'm going to put you in the waiting room.
Okay, if you remember from her soft sit video, she started out, and I left it in because I thought it was interesting, repeating herself, saying, "You're in 36th District Court, stay in frame," all this stuff. If you're wondering why she did that, imagine that. She does this every day. She does this every day. That was 3 days before this or whatever, and here's what she's doing. I saw a little bit more of the call. It never stops. I understand why she repeats herself.
What happened to Miss Marable?
Judge, she's in a waiting room.
Why? Okay. All right. And her client is Tyler. And I know I sent that phone to a breakout room. Let's see.
Yana, were you looking
Hold
for
on, Miss Marable.
Sorry.
That's okay. All right. Okay. Yes, ma'am.
Okay, so this is the defendant, bottom right here. Look at that. Again, this is why she repeats herself. She said you have to be in frame, you have to have a lit. I mean, who thinks that that's appropriate? That you're supposed to be in court. That looks like something out of like a horror film. I mean, if you don't give explicit instructions, this is what you get.
I'm back, Yana. I had I got a couple of devices going this morning for Zoom. I have 8 Zooms going on.
Oh, well, that's good. That means
My clients say you were asking for me. That's why.
Oh, no, I just said I didn't see you. You
Okay.
had went in the waiting room.
Okay.
But your client needs to do something else, honey. I say, honey, I'm so sorry, ma'am. We can't see you. That's not a good angle for your camera, and I'm not real sure why you would ever have a hoodie on your head. So let's take that off. I don't know what she's saying, but go in the breakout room with her and see what she's saying.
Okay.
And her no, I just said I didn't see you. Ma'am, please don't do that. Just wait. Let me run my courtroom, please. All right. I'm gonna send you to breakout room number 15, Miss
Yana, that's not a hoodie. That's a prayer cloth on her head.
Is it a required? Is it?
It's not a hoodie. It's part of my religion.
Stop. Please don't do that. I don't like it. Let me just tell you all that I don't like it. There's no free-flowing conversation in the courtroom. Let's do things decently and in order. Take the camera down from the ceiling, please. Now, either we're going to come to court and be appropriate or we're not. So let me run my courtroom. Please let me run my courtroom. Miss Marable, I'm going to send you to the breakout room and then you can let me know what the situation is so that I can address it appropriately.
Thank you.
You're welcome.
Miss Tyler, you're gonna see breakout room. Hit that, please.
All right. I put you all in breakout room number 15.
I absolutely get her frustration. I watched some of these calls to look for material for this, and all the judges are dealing with it, and it is so frustrating and completely out of line with what would happen in a court. It really is. I mean, people get a little out of line in court, and the judge will chirp at them there too, just like this. But for whatever reason, it just doesn't have the same gravity going in on Zoom. The attorneys know what to do because they're trained, but these defendants, they're not used to it, and they just can't make the mental leap that that this is a proceeding that they need to pay attention to. Michigan. I think it's Wayne County. And I know
All
it's
right.
36th District Court.
Ms. Marable, are you ready?
Yes, Your Honor, I am ready.
And what is the purpose of Ms. Tyler's headwear?
Miss Tyler is Muslim and is that's the traditional headwear that she has to cover her head. And I do have to say this, that we were in court. I've been in court with her twice, because the first time the preliminary exam got adjourned for lunch. And then we had to come back another day. So she's always had that since I have met with her, even when she comes to my office.
Okay,
So it's a religious.
thank you. I'll allow it. All right.
Thank you, Your Honor.
I don't know if you heard that, but she said I'll allow that, which is, I get it. I mean, how deep in this cross-examination are you going to go? She's there. She says it's religious. Fine. But every judge is just going to take their word for it on that because they don't want to look bad. And that makes sense. But what the judge couldn't take is the talking over and of course, coming on screen with a backlit without your face.
You're welcome. Okay, so this is case number 206050301, the people of the state of Michigan versus Shantae Renee Tyler. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning to this honorable court. Carla Marable, P number 62755. On behalf of Ms. Tyler, can you please state your name for the record, ma'am?
Shantae Tyler.
All right, today is the date set for a pretrial conference. How are we proceeding?
Your Honor, is there, from the prosecution, is there any offer, like a disorderly conduct?
Your Honor, at the time, there is an offer at the time. I still have to review the file.
All right.
So with that, Your Honor, can we have another date? Because I think that she doesn't have any prior criminal record. She may be an excellent candidate for a plea under advisement. And if not, I think that we have really good facts. We may just do a waiver in this particular case.
Okay, so that's the attorney thumping her chest a little bit, and that's appropriate on behalf of her client. This attorney actually, I think, does a good job for her, but she's saying, "Oh, this is minor," but if in there she was saying, "We'll do a waiver." I'm presuming they mean a waiver of a jury trial, so we can just do a bench. What she's telegraphing is, "I'm confident, Judge, that you will find my client not guilty." That might be bluster. That might actually be true. I don't know. She also seems awfully interested in getting a plea and getting her client done with this.
Okay, so Ms. Marable, let me ask this question. I'm assuming because this was reduced at the preliminary exam stage that you already have discovery, correct?
I have discovery.
Okay, so in that case, I apologize. Let me go get my other, I pulled the wrong calendar. Let me go get my other calendar.
And don't forget to hit like and subscribe, or the dogs get it.
Well, I cut it off there because it wasn't very interesting. What happens? I just know that people will want to know a little bit about it. It was mostly the beginning that was interesting. However, what happens is they set another date. They set effectively a status date to see if they can settle the case, because there's some pressure to get it resolved from the defendants, and the prosecutor just doesn't know what the offer is. And that's not crazy considering the volume of cases that they're dealing with. All right, so this next one is really cool. It's sent to me by a viewer. It's a new judge that we haven't seen before. Well, it's just new to me. I looked at it, and it's more out there courtroom behavior. It's kind of sad. Obviously, guys, we got a problem. You'll see, but it's an interesting bit.
Mr. Roberson, Mr. Alexander is here from the probation department. Katrina, do we have the hearing that you could play back?
Yes, Your Honor. I'm bringing that up right now, sir.
All right, thank you.
This is a little confusing because they're in a hearing right now, but then they pull up a prior hearing and it's them. So we're going back and forth in time here.
Are you seeing the screen, sir? I just want to make sure it's up.
Yes.
Yeah, but we're not.
All rise. 75th District Court is back in session. The Honorable Michael T. Carpenter presiding.
Thank you, everyone. Please be seated.
The video comes back on.
Who do we have in the Midland County Jail?
My
Please give
name
your
is Scott Robertson.
All right, we are on the record on the people of the state of Michigan versus Scott Robertson and the city of Midland versus Robertson. The city files are 21-1531 and 21-1522. With the attorneys in those two files, please identify themselves.
On behalf of the city of Midland, James Branson.
Your Honor, Peter Durant on behalf of Mr. Scott Robertson in both city files.
All right, and now for the state of Michigan. Is there a way to advance to the spot where we were talking about alcohol?
Okay, this is just weird. Now we're back to today, and from here on it has video, so it's interesting. But you know, back in my day, what we would do is you would have a transcript of the prior proceedings and you would read it. This is like really fascinating to me because they have these feeds. They just say, "Hey, pull the feed from that," and I think it's much more effective with video than with the transcript.
No, I don't see anything. Here we go. There we go.
One moment, sir.
Yep.
Thank you, Secret Squirrel.
I think you're going to do the other arraignment. That's true. Okay.
Thank you, Chris. They have the feeds, buddy.
Files are nonviolent. Mr. Robertson does not present a danger to himself or the community. He's currently sitting on incarceration. He is dealing with some medical issues going on right now, as well as mental health treatment. We would just ask the court to consider that in any sort of bond determination, specifically that Mr. Robertson is still able to receive his mental health treatment through CMH. Thank you.
You said is he incarcerated for any other purposes other than these 4 files to your knowledge?
Not to my knowledge, Your Honor.
Okay. All right. I will allow city make its argument regarding bond, and then I'll ask the county prosecutor to do the same.
Thank you, Your Honor. There are 2 files. One is a date of October 31st, 21, and the second is November 3rd, 21. Both are noise ordinance violations where he's disrupting the neighbors, allegedly pounding on the walls. Again, he's drinking or drunk at both occasions and making noise, yelling, screaming, and creating a disturbance. It just doesn't seem to stop. Alcohol seems to be the catalyst for it. He needs to stop drinking, and he needs to pay attention to be respectful to his neighbors in the apartment complex. With that, Your Honor, again, as Mr. Durant said, it's nonviolent, but it certainly is disruptive. It's ongoing. And as far as I'm concerned, Your Honor, he can sit right in jail if he's going to disrupt his neighbors and not have a civil place to respect neighbors and be a good occupant of an apartment building.
Thank you. Ms. Baumann, do you have a comment regarding bond?
Yes, Your Honor. I would echo what Mr. Ranson has just stated here. There's a misuse of 911, and specifically so that the defendant can get alcohol when he goes to the hospital or on the way back. And it is causing a disturbance with his neighbors to the point where he's banging on the walls because he can no longer call 911, but he can ask for help or say he needs help so that the neighbors will call 911 so that way he can again go through the cycle and eventually end up with alcohol when he comes home. I do have concerns that mental health and alcohol are big issues here, and I would ask that he's engaging in pretrial services in CMH so that he can address those issues because I think those are the root of the cause in both of these cases. I am concerned with his misuse of 911, but I leave it in the court's discretion as far as what to do with bond. I would just ask that there's engagement at pretrial services.
Help me understand. Thank you for that, but help me understand what your comment. You said he calls 911 so he gets help with alcohol. Is he asking the police to get him alcohol?
So what the report is essentially stating, what we're alleging here is that he bangs on the walls, so that way he's saying that he needs some kind of help, medical attention, till his neighbor calls 911. They send EMT or the police out. He goes to the hospital. Nothing seems to be wrong to keep him there, and his landlord will pick him up and take him home. But on the way home, that's how he gets his alcohol. He has him stop and get alcohol. And it seems to be in both of these cases, that was what he was trying to do, is get more alcohol. So that is what we're alleging.
Okay. Mr. Grants, may I address your client directly?
Yes, Your Honor.
Mr. Roberson, can you hear me okay?
Yes, Your Honor.
You've been sitting in jail for about 6 days, so you've not had a drop to drink since the last 6 days. Are you thinking clearly today?
Yes, sir, I'm thinking clearly.
I have a choice. I can just leave you in jail till we can get this figured out, whether you're guilty of these offenses or not, or I can let you out, but then you have to abide by certain rules. Do you think you could abide by certain rules if I let you out of jail?
Yes, sir.
What if that means no booze?
Hey, I'm all for that. I'm done with that, man. Stuff's kicked my butt.
Okay.
I'm serious. I want to get back into AA. I had 2 years sobriety, sir.
You had 2 years of sobriety. Well, that's a good start. Are you employed or do you receive assistance, some kind of financial assistance?
I get Social Security disability. So if I stand here, I'm going to lose my funding.
Well, that's where you'll end up if you keep on violating the law and you're found guilty of it. You understand that?
Yes, sir.
All right. I think we got you dried out enough. Hopefully you can follow.
So I'm just reminding you again, all this is them watching a prior hearing for reference.
The rules, but if not, you run the risk. You run the risk because you decided that the bottle was more important than your place. Katrina, can we get pretrial dates, presuming that I'm appointing an attorney for Mr. Roberson?
Is that good, Your Honor, or would you like more?
Yeah. Nope, that's good. So, Mr. Alexander, he told you that he drank alcohol this morning?
Yes, he did.
All right. He's remanded to the custody of the sheriff. I told you. Said the bottle's more important than your disability benefits. The bottle's more important than your place to stay. You're staying there till the sentencing on January 24th, which means you're going to lose your Social Security disabilities and you won't have anything to drink. So I hope that hope you enjoyed it.
I've only seen a couple things from this judge, including this video, because I only discovered him today. But he's a no nonsense guy. I don't think he's mean. I think he's fair, but he's not going to put up with this. I don't know if this defendant showed up to court drunk or if it was like a parole officer reporting that he said that he had admitted to drinking. But his bond condition was no drinking, and this judge is not having it.
You're remanded to the custody of the sheriff. We're adjourned.
Thank you, Your Honor.
Your Honor, I'm sorry. I did miss it in the mix of everything. Are we doing a PSI abbreviated or any? Do we need one? No.
No, we don't need one. We'll just sentence him on that date.
Excellent. Thank you, sir.
Late January.
Here at Law Talk, we like to have fun with silly stuff that happens.
Well, thank you all for coming out. I really appreciate it.
Once in a while, and completely by accident,
Sorry for being late.
You might learn something. Thanks for watching.